My heart beats a little faster than that.
Okay, good afternoon, everyone. I'd like to call the committee of the Special Committee on Assessment Practices to order. We'll begin with a roll call.
Mr. DeMarco.
Here.
Ms. Filiaggi. Mr. Bekowski.
Here.
Mr. Palmieri.
Here.
Chairman Catena.
Here.
Also have Mr. Klein on the phone, Mr. Macy in person. I think that's everyone.
Okay, we have approval of minutes 12566-23.
Approving the minutes of the October 25th, 2022 meeting of the Special Committee on Assessment Practices, which was recessed and reconvened on November 15th, 2022, November 22nd, 2022, and adjourned on January 17th, 2023.
Motion to approve.
Is there a second?
Second.
Motion has been made and seconded. All those in favor signify by saying aye.
Aye.
Aye. All those opposed? Motion carries. We'll now begin with agenda items 12525-22.
An ordinance of the County of Allegheny, Commonwealth of Pennsylvania, amending Article 209 of the Administrative Code of Allegheny County, entitled Office of Property Assessments, Section 5-209.05, entitled Chief Assessment Officer, Duties and Responsibilities, in order to establish a mechanism for ensuring continuity in the Chief Assessment Officer position, sponsored by Councilmember Catena.
We'll read the next one too, Jared, because I don't know if we're going to vote on these today, depending upon all the information that's presented. We might need to think about these and possibly offer amendments or what have you at a later date. So 12526-22.
An ordinance of the County of Allegheny, Commonwealth of Pennsylvania, amending Article 210 of the Administrative Code of Allegheny County, entitled Assessment Standards and Practices, Section 5-10.06, entitled Revisions of Assessment Role, in order to establish a mechanism for implementation of court-ordered revisions, the factors used to render assessments uniform in years in which no countywide reassessment takes place, sponsored by Councilmember Catena.
Thank you. At this point in time, I'd like to welcome our honored guests, Mike Suley, Joe Silvestri, Jen Liptak from the administration, George from our county solicitor, Jen Garafolo, Jessica, I'm sorry. So at this point in time, I'm going to give you guys 15 minutes to do your presentation. And I think we have Barb on the phone. Barb's going to do the presentation. So Barb, at this point in time, if you want to do the start with the presentation.
Asking for the update. No?
Did someone speak to me? I'm sorry.
Who's going to do it?
Hello?
Who's going to?
No, I asked Barbara to be present.
Okay. So you're going to do it? Okay.
Yeah.
Okay.
What I prepared for today is integrated with giving an update of what's going on. The lawsuit, I'm going to talk about 4 lawsuits. The lawsuit that everybody talks about is the one where Judge Hertzberg ordered the common level ratio to be 63.5%. And that was based upon the county data and the county deciding what data they wanted to use. The plaintiffs had nothing to do with the approval or the pushing of that data to the court. The transcript of the county is very clear that if they wanted to reject anything that the plaintiffs presented, they did so, and they did in fact do so. So that 63.5% number is the county number. So the next step in that case is there's an argument scheduled for April in Commonwealth Court. I'm going to leave that case because there's another case that's against the Board of Assessment. And in that case, it's going to be argued on February 27th before Judge Hertzberg. And in that case, the issue is whether the 2021 common level ratio should be applied to the 2022 cases. There are arguments on both sides. I'll just say that if Judge Hertzberg rules that the most current common level ratio published, which is the 2021, applies to the 2022 appeals, then it really renders the school district appeal moot. If they lose, they lose. If they win, they still lose, because the only purpose of the appeal was to hold up people from getting their reductions. The third case is 2021 common level ratio. Although the county did that by redoing the computer program falsified information, what they did not do, which was done before Judge Hertzberg, is review the manual fraudulent coding. In a prior council meeting, I had what I called the cheat sheet, the manual cheat. I think I call it the manual cheating sheet. And that sheet was testified to by the coders. Even Jessica Garafolo testified that she used it, as is typical of that type of testimony. She wanted to sidestep by saying that she ignored the part of the cheating sheet that said that you automatically code as valid high ratio sales. I mean, I'm bad at typing. My secretary does the typing. It would take me all of 5 minutes to type a new sheet without the wrong information on it. So I don't know why we have that testimony in that sheet. The last item, and on that common level ratio, I'd like to jump ahead on that presentation up there to page 4. We've had a very significant development in Harrisburg. What is going on is all the briefings been done. I would expect a decision in the month of February on the 2021 common level ratio. And if we can go to page 4 of the presentation, it is a verification by Renee Reynolds, who runs the State Tax Equalization Board. And what I did was highlight this, but the bottom line, if you don't want to read the highlights or the whole thing, is that the State Tax Equalization Board is taking the position that doing an audit, doing a review, looking into the coding of what the counties send them is not their business. And the briefing that was submitted by...
Excuse me, John. Folks on the phone, if you can mute your phones, please. We're getting some background noise in here. So if you can mute your phone so we don't hear anything, that'd be great.
So, the briefing of the State Tax Equalization Board attorney was just that, the controversy over the coding belongs in common police court. The hearing examiner, through briefing discussions, indicated that if the State Tax Equalization Board gets its way, and I'm not unhappy if the State Tax Equalization Board does get its way, then there will be a transfer of jurisdiction from the State Tax Equalization Board to our Court of Common Pleas, so that all the coding can be done locally, and there won't be all of these, what I would call dumb lawyer arguments that there's an administrative remedy. So that first paragraph 7 on page 4 says that this common level ratio is based exclusively on information reported by each county. So they're not doing an audit. If we go to page 5, in paragraph 26 that's verified, what it says is that as a practical matter, it's not Renee Reynolds' words. My words are, there is no way, Jose, that they're going to do an audit. They just don't have the staff or the money to do so. And then, of course, when we go to page 6, you see Renee Reynolds' verification as the executive director and director of certifications, that this is true. So I think that we're going to be coming back on these common level ratio issues without a bunch of lawyer objection rigmarole in the future. And that is pretty much integrated with the first piece of legislation. I was reading the paragraph C, that when people go to hearings with an inflated common level ratio, for example, the 63.6 is inflated because the manual coding falsifications were not reviewed for correction. That common level ratio is 57%. I'm perfectly happy to take my cases through the judicial system, the Board of Assessment system at the 63% for 2021. But it would be fantastic if the property owners would get the straight count by legislation that I see in your ordinance that would require an adjustment of any common level ratio under appeal. Because people should be taxed by the correct amount, not the Fitzgerald administration cheating amount. The last litigation is a new litigation. It's a petition. The reason I asked Barbara Stern to be on the telephone is because the more the Fitzgerald administration resists doing the right thing, the more we investigate. And what Barbara Stern uncovered using her mathematical and computer science skills is a forensic study that shows that we're getting very close to clear and convincing evidence of fraud. The first page of the presentation, I really didn't pay attention to early on, but that's the state law that says there are to be reports every month to STEP. The short story is by the 15th of a given month, every sale is supposed to be reported to STEP the prior month. But what the forensic study reveals, and we get into the forensic study results on pages 2 and 3, is that when the county initiated section 15 to cheat on the reporting to the State Tax Equalization Board, they weren't reporting sales on a monthly basis. In 2016, when Jessica Garafolo called the meeting, and that's deposition testimony of the former acting chief assessment officer, which resulted in inserting the second cheating section, section 4B, there were no sales reported in 2016 during 2016. And a more recent forensic study was done on the section 4B operations. And apparently, when Jessica Garafolo called her meeting together and had the code changed to add the cheating section 4B, they did too good of a job, because what we're seeing in the forensic analysis is that internally, the Office of Property Assessments knew that their ratio was inflated. Believable. So what we see is backpedaling to bring it down into the 80s, as if keeping it at 80 something every year is correct. So this fourth lawsuit, since we're having these forensic studies being done, is to ask the court to void the determinations by the Board of Property Assessment that were used where the 87% common level ratio was used year after year when it shouldn't have been used. There is clear legal authority. Our judge, retired Judge Manning, wrote about it in detail, that if evidence is submitted in a proceeding that's fraudulent, you're entitled to have the result of that proceeding overturned. And the common level ratio is nothing more than a piece of evidence in a tax appeal. It's a fraudulent piece of evidence. And so I wouldn't have been doing this legal research except the Fitzgerald administration wants to do not the right thing to correct. So long as they resist, we're going to dig into the facts, we're going to dig into the law, and we're going to keep on proceeding with this. So that.
Hello?
Marco, anything?
Couple things.
Oh.
One, I would hope that when you come before us, Mr. Silvestri, that we can withhold the cheating and the fraudulent, let the court roll on that, okay? And because I don't think that serves to help. We all recognize that there's a problem here. We're here, this committee is here, been formed by the chairman, because he wants to fix these things and solve them for the taxpayers. But it was very hard to follow your report here as you jump from the first page, then through here with the cheating, the fraudulent, the more lawsuits you're talking about. So when you're talking about all the lawsuits, it makes me wonder, what the heck are we supposed to do in the interim here as we try to solve a problem when you're telling me there's these cases that have been filed or they're in court and we don't have an adjudication for them yet, right? So, I guess, what I took away from the presentation, there were things that weren't being done. Monthly reports of the data, sales data should have been reported to STEP. Wasn't happening. Is it happening now?
We don't know. That's one of the pieces of legislation. It's not at this committee this evening, but I did read legislation, another proposed ordinance that's in discussion, that would have a requirement of county council auditing. The only comment I have for that is that everything that's reported to STEB is a public record. If you'd ask STEB for it under the right to know, you'd get it. If you'd ask the county the right to know, you get it. My suggestion is that if you're going to go forward with that legislation, instead of having an audit at the end of the year of what the county government has done, you require the county government to give you the information monthly. And they're giving half of the information monthly right now on a real estate website. All that they have to do is add the information to that website that they report to STEB. And then every month you would know how many they're reporting to STEB to know if they're following the state law. And you'd also have the ability to audit it, not only you and your consultants, but also any member of the public who's interested.
And I followed that piece, right? And your recommendations are that we have the programmers change the website and to reflect the ability for the people to be able to view these other fields. Okay. So excuse me, Mr. Chairman, that's something else that we should be looking into, but that seems reasonable. We want to increase the transparency for the folks out there, right? But I guess like confusion for me is now all of a sudden, when I came in, we were talking about, we're looking at the ordinances that the chairman has sponsored and which I, support, right? But we're talking about the court case that you're talking about. You're talking about a decision in February, but everything I read was that we're not expecting a decision from Commonwealth Court until April. And this was on the appeal. They did the arguments, but we weren't expecting a decision based on the post and debt secretaries until April from Commonwealth Court.
Now, the argument's in April, so you may not get a decision until May
Or even later, okay,
And that decision is subject to further appeal.
okay.
So the legislation that you have here is very, very important because the more court cases there are that have the common level ratio in dispute, the more pertinent this legislation is, because when those cases get resolved either this year or next year, and sometimes even the year after, when you finally get a final determination, a final judgment on the ratio, what this legislation does is it substitutes what is correct for what has heretofore been incorrect.
Well, so in following that, and I apologize for.
No, go ahead.
Okay, so the court case that was filed basically for the CLR for 2022.
2020, no, for 2020.
But for the people,
For the 2022.
for the 22 tax year.
Yes.
I'm sorry, okay, right.
So
So in 2022, haven't all appeals been frozen or put on hold? So no taxpayer has had to pay on a 2022
if
tax
there's a
bill
market change.
with a CL, with a market, right, CLR.
Yeah.
Right, okay.
That's my understanding.
Right, so, I guess, because again, this is complicated. That's why we're having multiple meetings, trying to understand it. And the chairman and I have had multiple discussions. We want to make sure that the taxpayers of Allegheny County are protected and receive everything that's due to them. But we got a court case that's for 2022. Right, or for 2022, 2020 assessment or whatever. And then you're talking about different years in here, right? And so I want to make sure that any legislation that we put forth and we vote on, sort of addresses what we're trying to do for the taxpayers, but doesn't run in contradiction to what the court's doing or looking to do.
Your legislation is integrated with the court.
It is.
If someone says the common level ratio is too high and the court says we agree it should be lowered, whoever had their decision based upon the too high ratio gets lowered under your ordinance. So what it does is it works with a court decision, not contrary to a court decision.
Right, but we have some language in here we need to change, we know.
We would,
Like
yeah, we
people
need to
are-
amend.
We need to
it.
go to step
Yeah,
and
that's
stuff
why I
like that,
said,
right?
yeah.
Yeah, so, I mean, I guess, I'll stop for now, I'm just. Again, with 4 court cases out there,
It's gonna, I'll
it's
just,
getting messy.
yeah, with 4 court cases out there, it's gonna. I don't know how we proceed with any of our legislation until some of the court cases are adjudicated, to be quite honest. I mean, what are your thoughts on that? I mean, it's gonna get confusing.
I'll speak first. We'll end up with Judge Hertzberg. That's what I believe will happen. And he will make all these decisions, quite possibly will be resolved this year. The only thing that matters, we sued for 1 year, 2020. Now there are 2 more years in play. We have no idea what the honest common level ratio is. So there has to be an outside audit.
I mean,
That's all.
just play devil's advocate. How do you not only know there's gonna be 2 years in play? I mean, is there more lawsuits that could come out and there's more?
2020 is 63.53, 2021 is 63.6. That means property values went down. No, there's no way. So you have to conduct an audit. That's why we started this process in the first place. The ratios, it will end up in the 50s after 2 more audits. 2021 and then last year's 2022, there has to be an audit because Judge Hertzberg may rule that the 2022 CLR will be used this year.
Man, to me, this is a little bit confusing because it's like we started, I mean, if you're trying to follow, but we're like in the middle and
Yeah.
then we're jumping over here to the beginning and we're looking at this number and now we're going back. It's like you want to go consecutively back and
It's
we
audited.
and we didn't. I mean, that's just the confusing piece like that.
I understand. It is confusing. But the bottom line is people are being overcharged right now, going back 6-7 years. And, the judge may, and John, this is John's department, the judge may call for audits of those years. Your legislation will equalize those decisions from those years and make it fair. But it sounds like there's a lot going on. But the bottom line, the true, honest, common level ratio for each year. And I believe STEP is saying, hands off, we're not going to do anything with this. They're recommending it goes back to Judge Hertzberg. And Judge Hertzberg right now is in charge of all appeals that go before common pleas court dealing with the common level ratio. So he's focused on this like a laser. In his world,
Mr. Chairman, a number of meetings ago, when it was brought up about doing an audit, I think you inquired as to what the cost of doing an audit is. Might not be the best case here is for us to determine what the cost of doing an audit is on an per year, right? Then trying to go back and look at where do we start and engaging somebody to go back and do the audit for this past number of years. So they can come back to us with the definitive answers, right, of what it should have been
peace of mind.
in those particular things. And it's going to tell us two things. It's going to tell us, A, either in some years, the COR was where it needed to be, or in other years, it wasn't and what it should have been, okay? And I think based upon that information, then we might have what we need to be able to craft something to put in place, something that addresses it all as opposed to,
I'm open to that.
I mean,
Yeah,
I just don't know how
I'm
else
for
to
you.
proceed, right?
I mean, we originally talked about that a few meetings ago, but we sort of kicked that can to the side, but I'd be happy to pursue that. I mean, I think that's the only way to try to get to the bottom of this.
Yeah, exactly.
Excuse me, may I
We're
say
not
something?
capable of doing it.
Yeah,
You know, I'm not gonna wait to Judge Hirschberg.
Barbara.
Yes, may I say something? Is
Yes.
that permitted? Forgive my informality. Yeah, I was only going to say that through our work, one of the methods that we use as sort of a check and balance for our work is information that's available through the West Penn multi-list. And John refers to this as the common law method. And when you use the entire set of sales, every sale that was offered on the multi-list, consistently the number, if we compute a ratio from those sales, is very, very close to what a common level ratio should be. So if you were interested, that would be a start to see how far this common level ratio that's been computed for each of the years of concern deviates from all of the sales submitted on the West Penn multi-list. We can tell you from our experience approximately what that could be. And if it's a huge deviation, it might suggest to you that the common level ratio is significantly off.
I think that would be helpful, but I think for our purposes, you know, if we had that information from Bart, you guys were able to provide that. But I think for our purposes, we would need to have it from a third party as well. So some sort of audit, you know what I mean? So
I agree.
you're right. So it's just
We did 2020 pro bono, the three of us plus a team of statisticians. It can be done. But the West Penn multi-list data, there are 16,000 closings each calendar year. That's a wonderful resource to start doing this. The county wasn't using the multi-list.
and that'll give us even if we go through with them, that'll give us an idea, but that's still not going to give us the authority to go back because steps basically validated those numbers. So it would have to be through court order that those
Right.
would get changed.
we're cases on
Yeah.
That's what Judge Hertzberg did in our case. We worked with the county, they worked with us.
But at least we know.
And that's why, to your 2 point, your legislation here only affects 2022, right? Because that's the court case that's in place. But you talking about the court case, we can't write something.
That hasn't been,
Right.
yeah.
Maybe I misunderstood your legislation, but I thought that your legislation applied going forward basis that.
Going forward, but it doesn't go
It
back.
doesn't go back.
Oh, yes, okay. Yeah, yes, well, that was the reason for the fourth lawsuit to go backwards, to void what was
So
done.
then the legislation would, if there's the fourth lawsuit, then we have the mechanism.
Then we could change the
Yeah.
legislation, right? But I mean, right now, we're just talking right now.
Yes, I guess from client's point of view, your legislation solves 90% of their problem because they're really interested on a going forward basis. From an academic judicial point of view, going backwards and to what was done wrong and burn some people's minds that what was done wrong should never be done again.
Well, we want to correct, obviously, the past mistakes, but then make sure that it doesn't happen in the future as well, obviously. Councilman Paul Mary, any questions?
No, Mr. President, thank you.
Councilman Macy?
The only thing that I'm really garnering from all of this is that there's a tremendous amount of variables. There's a lot of information that needs to be gathered and for the court cases. And that information can't be, until the court decides, we can't really come forward with any legislation that's going to be quote legal, right? So I think there's a lot of more information gathering that has to be done. So we know specific, because I've heard the term if, maybe, wasn't done, should be done. I'm confused.
We conducted a review of 2020.
I understand.
It was
What's
done.
in the court and what the judge has said is not necessarily final.
Won't be 81. That's a Hail Mary.
Well, but you don't take and put legislation in place to change it if you don't know what it is gonna be,
Right.
you know?
But the judge has already said what it was, based on what
Judge Hertzberg said,
Fitzgerald administration and the plaintiffs agreed on, not the Pittsburgh School District. They had nothing to do with.
Oh, these are the county's numbers. These are not the people who filed the lawsuit.
Right.
63.5 is Allegheny County's number. It was presented by the law.
Right, that's important. That's important to them. So it can be done, it will be done. And the only if is, it's like calculating a batting average to statisticians. That's what I've learned in this process. Whatever that number is, times the market value, that's it. See, the appeals board can continue doing its work. What is my house worth? 400,000. And the judge comes down with that number, and we just plot a number and you send out.
absolutely.
notices.
I think we all
So
agree on
it's
that.
not-
Yeah.
See, in our world, it's not that complicated, but it looks like all these moving parts.
Mhm.
But to simplify this, Bob, whatever the common level ratio is, if they say it's 81, so be it. I'm fine with it, but it's not. The Fitzgerald administration and the plaintiffs worked together. Barbara Stern worked with the manager of property assessment, and that's the number they came up with. And the attorneys for the county, there was no dispute on that number. It wasn't the judge's number, everyone. And it took 4 months, but John and I and Barbara were saying 64% 18 months ago. We knew.
I think, look, Mike, I don't think anyone's arguing
No.
about the 63.5, okay?
Right.
And I understand what you're saying, that the 63.5 was arrived at with data that was provided by yourself and the county.
Correct.
So you guys are agreeing with that. Now, Judge Hertzberger, he agreed and made the judgment, and his opinion was based upon that, okay? I
Right.
get that. But we have these other court cases that are out there. You're talking about other years, both earlier and going forward. You know, I just want to make sure that whatever we do addresses it, because our legislation only addressed 2022.
Agree with you, sir.
And then when we talk about the damages to people, right? If that CLR for 2022 hasn't been applied to the higher one yet, I mean, it's all. Okay, so no one's been hurt. It should be at this point, right?
It's in doubt.
Right, it's all in doubt
Yeah.
until we get this decision. And
Correct.
I think wouldn't be a bad idea is for us, if, you know, if I may, just offering a suggestion to my fellow council members, what might be a good idea for us is to take, while the Commonwealth Court case is proceeding until it's ruled upon, to use this to look at somebody that could do audits of these other years, just so that we can, not only for our own use, but be able to go back to the taxpayers and say, look, this was brought to our attention. This is something that should happen. This is something that needs to be corrected going forward. But we've also looked into it so that we know whether there was a problem in earlier years or when it started or when it didn't. You know what I mean? Again, you know, you guys have uncovered, you know, a bit of a mess. I want to, you know, tear away all the stuff, find out what is the total exposure or scope of what we're looking at here. And then from there, we could be able to take and craft legislation to address what we believe is the best path forward from there. Does that make sense, Pat?
Yeah, that makes sense.
Could
Councilman-
I just say, is it possible that you could direct the, a review that they themselves recode the 2019 submissions to STEP? What was directed by Judge Hertzberg, what they admitted was incorrect, was about 5,000 sales that had been coded as a special warranty. All 5,000 went into the garbage can. But as a result of the litigation that was brought, those special warranty sales were treated badly, weren't reviewed, and were only put in the garbage can if they had low ratio. If they had high ratio, they were accepted as valid without further review. It's possible, certainly, that the county could go back and revisit all of the 2019 special warranty sales and themselves recompute a new ratio. It's doing the exact same work that Judge Hertzberg ordered that they offered to do. It's only about 5,000 sales, and it shouldn't take very long. And that would fix, I'm going to really just approximate, maybe 50% of the incorrect submissions. Now, there's a whole, and Mr. Wahola and I spoke about this briefly, there are still many, many, many improperly coded sales for various reasons. But that would be a start.
Well, I think,
It's just a suggestion.
no, this is a reasonable suggestion, right? But what I'm looking at is trying to, if we're gonna do this, not do something that's just a start. I'd like to really just do a thorough examination,
Do
right?
it all at once.
Yeah,
Gotta do it.
yeah, get it done.
Yeah, I agree. Councilman Klein, any questions? Councilman
No questions,
Palmasina, any
Mr. President.
questions? Thank you. Councilman Palmasina?
No, thank you, Mr. President.
Councilwoman Bennett?
No, I don't. Thank you, Chairman.
You're welcome. Councilman Bukowski?
No, thank you.
Councilwoman Falagi? Not there? Okay. Did I miss anybody? Is that everybody? Okay.
If I may just have one more sentence. The legislative solution is always the best solution. I would love to see the legislation resolve the problem and just discontinue all of the lawsuits. I'm not interested in propagating lawsuits. I'm interested in fairness for the property owners.
We're interested in the legislative solution too, but I think we need to get the full picture of this to fix the past and the present.
Yes.
So, thank you, guys.
Thank you.
Jen,
Good luck.
do you guys want to come up? Would you?
That's really stopped the home.
No, anyone can say, right.
Jen Liptak, Jessica Garafolo. I'd like to start off with, if I may, Chairman, thank you for having us. Thank you, council members and those on the phone. I thought we'd give an update on what currently is before the BPAR board, just to create some clarity about the 2022 appeals, how many that have been heard, how many are still in the pipeline to be heard, what the BPAR board told us they're doing with regard to any disposition on those. And then just a little bit of background, if Jessica wants to just talk briefly about the two ways to apply for appeal. One is based upon market value, one's based upon base year, just to create some clarity. So if I may, I'm turning over to Jessica. She's just going to give a real brief, just a summary on that thing, and then just go over some numbers. Is that okay?
Yeah, so I'll start just with the general of how to file the appeal. So any taxpayer, or really any interested party, owners, school district, or municipality can file an assessment appeal on a property for the given tax year you're in. This year being the exception because we have 2022 and 2023. But anyone can file. They have between certification of January 15th through March 31st. Once they file, the Office of Property Assessments will schedule the appeal. It will be held with a hearing officer appointed by the Board of Property Assessment Appeals and Review, BPAR. So typically the property owner in the school district or the municipality will be present for the hearing. They get sworn in. Right off the bat, the hearing officer says, this is a base year appeal or a current market value appeal. Base year appeals are 2012 base year. That's what we did our reassessment on. If you haven't sold your house recently, in the last handful of years, you haven't received a change notice from a change, your value is probably the same as it was in 2012. I know mine is. I bought my house in 2009, haven't done anything else. That's the base year. Current market value is more so those recent sales. A lot of times you'll see that with school district appeals. So right off the bat, that's how they start the hearing. Only hearings that are being held for current market value are the ones subject to getting common level ratio applied. The real purpose of common level ratio is to trend a current market value back to what the base year value would be. So I think that's important to note. And Councilman DeMarco, summed it up pretty well. BPAR has frozen all of those appeals. When I say frozen, they've heard them with the hearing officer, but the board hasn't issued a decision on anything. They haven't said, homeowner, here's your new value based on your appeal. So the hearings are taking place, and we have about 10,000 of them in limbo. We had 12,000 total filed for 2022, not counting the new ones.
How many was that?
12,790 to be exact, were filed in last year's 2022 window. And as of the last board meeting, which was 2 Thursdays ago, the board had only issued dispositions on 450 appeals. And most of those were no value changes, or they were base year value changes. So they haven't issued any dispositions on anything that has common level ratio applied to it. And again, as Councilman DeMarco said, those are all frozen. They're holding on to those. And I confirmed this with the board solicitor earlier today. They're going to hold on to those until all court proceedings have been adjudicated and an actual final common level ratio has been decided. So those are still in limbo. As we get into numbers, again, that's roughly 10,000. 9,000 heard, and they're sitting there waiting for that common level ratio to be decided on by the courts. And then there's still like 1,000, maybe 1,100 that the Office of Property Assessment is still in the process of scheduling.
But can you also add how many, if I may, I wanted to add that for the ease of the interested parties, primarily the taxpayers, these are all being held over the phone.
Correct.
So no one needs to drive downtown, pay to park,
Right.
go through a metal detector, go up to a building and have their,
Right.
they're being held on the phone to try to be as user-friendly as possible.
Question. Is there any way to make the directions a little bit easier on the website for filing for 22 and 23?
Sure.
Because right now, what I'm afraid is people are only gonna fill out one form and they're gonna miss, I mean, the 2 years, the 2-year window.
Like just a thought, like you think like maybe on like the main page or 2 things, or like on the assessment page, just a little bit clarity, like you have to fill out 2, what you do.
Clarity about, they need to fill out 2. I mean, both forms need to be completed.
That's an issue at all. We can probably put a little more prominently on the main page, the landing page, and then maybe a little bit of language of clarity on the assessment page where you'll find those forms. Yeah, I can do that.
Okay.
And I'll let Ken know when it's up so you guys know. Is that okay?
Yeah, we can put it on our site too to make us.
Absolutely. If you'd like a link,
Yeah.
if you'd like a link, you know, I can tell, we can tell IT that you'd like it, and then they'll have to contact you because it's your page to do it. But we can start that process, and then they'll contact your office because we don't change your page.
Brett is just saying that, I mean, make it clear that the parties of the 2022 have the right to file an appeal. On this.
I say you can't tell what's going on.
Sure.
And why do you have a 2022 in addition to a 2023?
Okay.
And I think people are going to fill out one and not the other. And this is the 2022.
Jessica does have an update on the number of appeals filed under the new window you guys just approved. So
as of about 3 p.m. today, we're up to 91 appeals for 2022. 90 of those were owner filed, and we had 1 school district filed.
We'll open it up to questions. Councilman DeMarco?
Sure. I don't know if you folks were following what the presentation Mr. Silvestri was giving, but he talked about what one of the things that folks would like to see, or they would like to see, on the county web page where the county reports sales. We're asking for 4 additional. Just wondering if any of this problems we're having our IT folks modified. So they're saying that right now the county report includes a sales date, seller, buyer, tax, parcel number, address, and sales price. An additional report, sales report step on the same webpage. We have the date the sale was reported step, the code, and then it says that. Okay.
So I think you're talking about on the assessment page. It's a You're talking about that, on our assessment website where you can look up your property value.
This is on the information portal.
Information portal.
So this is the real estate web portal we're talking about?
It's the info portal. That's the connotation.
Right.
Okay, okay.
I'm looking at this, it's all in bold, so it's kind of making my eyes
Yeah.
spin a little bit here, because it's kind of.
Basically, it's just if you would require someone to just code the program and create 4 more boxes and have data flow to those boxes, but I don't know what's involved because I'm not familiar with the software underlying the portal.
I'll have to, I can't, I'll look.
Okay.
The other thing that was mentioned in that, the reporting to STEP. Is the reporting to STEP happening as it should be okay. What, was there a gap at one point then, or?
Aware of any gap.
Okay. But it's happening now.
It is.
Okay. I'm sorry, Councilman.
No, you're fine. These are all good questions, right? The other thing is if we were to take and engage county council were to ask for someone to do the audit, okay? We count on the cooperation administration to cooperate with these folks performing the audit to ensure that they have access to all the data that we're looking for the sales.
Becomes a little bit complex and complicated, and it would depend on, and I'd have to check back, it would depend on what the scope is. And I was reminded that, we get changes for values from building permits. Okay, so if municipalities don't require certain things, it's just consistency with what's required from one municipality to another. We have 130. Please correct me if I'm wrong as I'm continuing through this. But there's differences in requirements municipality. Not all municipalities submit building permits, which then prompt us to review the property for a potential change. So that inconsistency doesn't necessarily match up with, say, like a multi-list or some other document that may have all that information, because we don't get building permits that we ask, but we don't get building permits for every single change in property. Some municipalities, I think Jessica could say, are probably really good, do it all the time.
We have a lot that are, and to Jen's point, we have unfortunately too many that aren't good. Some never send them, some send them once a year. So that makes it hard to maintain accurate building data.
And I understand that, listen, there's no perfect world, all right? We're only working with the data, the information that we get, okay? But like they mentioned, I think Barb mentioned is 5,000 sales with warranty day, right? I want to make sure that whatever we're capturing, we should be able, we can't capture something that wasn't given to us. But I want to make sure that we're able to look, or whomever does the audit is able to look at all the data that we did get and that we did have that went into taking into developing what was the next step.
Understand the scope and such and what exactly the method is. I think, but I don't want to get into anything related to pork. I don't think that's food or anything like that. But what I can say is I think the intent of council is the same as the intent for the executive branch, which is we want to do the best for the taxpayer.
Yeah,
I think that's been proven by you guys over the years and us as well.
Yeah, the
So
county executive has been great signing the appeal legislation that we passed and putting it in place.
that was a good idea. So
Yeah, he's told
no
me,
issue with
he
that.
told me multiple times. He just wants people to only pay what they have to pay. No. Yeah, so I guess, I understand that you can't commit to everything, not knowing what we're doing, but I also wouldn't expect any objections from somebody just reasonably asking to see the base information that we're looking to see either, right? So I believe you couldn't anticipate anything other than us trying to do something out of scope or that we were asking for something that you didn't have.
But yeah, again, I mean, there's a difference between a review and an audit, okay? So an audit is defined, usually falls under, it's a whole different, so sometimes there's reviews done, sometimes there's audits done. I'm not sure what the intent.
That's what happens when you're not an
Right,
accountant.
so that's where-
I use the term, right? I think a review would be.
An audit usually, I mean, it also is looking at process and procedure, so I don't want to get into all that, but what I can say is that, we're here to help and talk and explain. That's why, the chairman, talked about us presenting and, we're happy to come and do that for the chairman today. And give an update on what we have. So, want to keep talking. We also, but again, I, applaud, council and I'll applaud the executive too, because I think from both sides, the interest of taxpayers has always been the forefront. So you guys should be recognized for that.
I think we have some, I mean, we have to get together and figure out what we want to see and then go back to them and basically, but I think we need
That's
to
fair
come
enough,
up with the
yeah.
structure and stuff, and then provide it back to them to see what exactly we can get it, make sure it's consistent or consistent across the board to make sure everyone's looking at the same apples to apples per se.
Mr. Chairman, would you like a really quick update on where we're at with the chief assessment officer search?
Yes, sorry, I wanted to bring that up. Yes.
I wanted, if we're okay moving beyond this topic, can I?
Yes.
Real quick one. So as you know, we have someone in place now, but we did engage a firm. It's
GovHR.
GovHR, and it's a pretty prominent government geek. I mean, I'm government geek. So for government type jobs, this is a really government job. You don't go to school to be like a property assessor. That's not, you don't really go to like college for that, right? You kind of.
We always say no one, when they're little, says, I want to be a property assessor when I grow up.
Like,
Like me.
Hey, don't insult Mr. Suley.
There's no degree for property assessor. Like, I'm gonna go to school like a nurse or something like that. So, we engaged GovHR to do what we hope to be an aggressive search like we do for a lot of our prominent positions. And they have a description they put together, and it's based upon, you know, what's already publicly out there. And we're hoping to start to get some resumes back, you know, end of February, March, and they'll do a screening process. So they'll go through, because they want to make sure, we don't want people applying that obviously, you know, we don't need to, that don't meet the qualifications, and go through a process to try to really aggressively try to find someone. And it's a very difficult position to fill. I can tell you, it's not easy. It's very, very difficult. So, but, yeah, we've actively engaged a firm, and, you know, we're hoping to get a good outcome, with some candidates. Okay.
Okay, thank you.
Very well.
Councilman Bukowski, any questions?
No, thank you, Pat.
Councilman Klein? Councilman Palmieri?
No questions, Mr. Chairman. Thank you.
Councilman Palmastino?
No, thank you, Pat.
Councilwoman Bennett?
No, thank you.
Councilman Macy?
No, thank you, but I have 8 credits in real estate. Can I apply?
That's right. Yeah.
Any, go ahead.
Could I just ask that you just keep us updated?
Yeah.
As to where you are, once you feel that you've received, you start interviewing.
Yeah.
Okay, and as you get closer to making a hire, just so that, the chairman knows, we know, you know, where we're at.
You're conducting the search, and it's great. You're going through, some of this is, like I said, trying to fix the future, or trying to prevent things so they don't happen again. And that's why the chief assessment officer came, because I think there might have been a gap in the past. And that's why I'm, like I said, just want to make sure that in the future that there are no gaps or what have you. And that way we solve for it moving forward. So potentially that never happens again if it did happen. So, but like I said, if there's no other questions, then we'll go into recess at this point. Thank you, everyone. This meeting's recessed.